Okay, I'm going to get started by introducing you to the moderator of this panel, the Honorable Donald W. Molloy, who is a federal district court judge in Missoula, Montana. Judge Molloy has been serving in the federal judiciary since 1996. He was the chief judge of the federal district court in Montana from 2001 to 2008. He graduated from the University of Montana. He was actually a running back for the Grizzlies. He then went on to be a Navy pilot during the Vietnam War. He also graduated from law school in Montana in 1976, after which he clerked for Judge Batten, who was also a federal district court judge in Montana. He practiced in private practice as a trial lawyer for nearly 20 years before he was appointed to the federal bench. Serving on the in the federal district court, he has served on the Ninth Circuit Judicial Council, the Chief Judges Conference, and the Judicial Council's Executive Committee. And he is now currently on the Federal Criminal Rules Advisory Committee. Welcome, Judge Molloy.
Thank you, and I appreciate the introduction. It's nice to be here, the last panel of the day, and I think you got most of my biography right, except that I'm no longer on the Criminal Rules Committee. That ended October 1st, so I'm no longer on that committee. So. It's a real honor for me to be here with a distinguished panel of academics to discuss issues that are related to the National Federation of Independent Businesses versus Sebelius, and that is the Affordable Care Act. And we have a number of very distinguished speakers, one of whom I think you've already heard, perhaps more, but that is the first speaker is going to be Professor ILya Somin, who's at George Mason University. And I know that he has been introduced in the past, but he is a professor of law there. His research focuses on constitutional issues, and particularly the issue of federalism, property law, and then he's written some articles that we're not going to discuss today about popular political participation in democratic government, which is fairly critical of jurors, and I would love to have a debate with him sometime about that, but we won't do it today. Before he took his position at George Mason, he was a Olin Fellow at Northwestern, clerked on the Fifth Circuit, and he is an adjunct scholar at the Cato Institute. He did graduate from Amherst, and has not only a bachelor's but a master's in political science from Harvard and a JD from Yale Law School. In his topic today, he's going to talk about the U.S. Supreme Court's interpretation in Sebelius of the meaning of the word proper in the necessary and proper clause, and he's going to share his views of Chief Justice Roberts' explication of that particular issue, and his view is that Chief Justice Roberts has fleshed that out in the most thorough opinion in the history of the United States Supreme Court. The next speaker is going to be, if I understand the order here, Professor Erin Ryan, who's at the Lewis and Clark School of Law. She's an associate professor of law there and specializes in natural resources and environmental law, together with property law, land use, and water law, as well as federalism issues that she deals with. She has presented both to the Ninth Circuit and to the USDA, to the Office of Ecosystem Services and Markets, and to the United Nations Institute for Training and Research. She's appeared a number of times on PBS and on the NewsHour, and has, I think, written for the Chicago Tribune, the Financial Times, and a number of other publications. Uh, so when she speaks, she's going to talk about the impact of the Sebelius decision and the court's new spending power doctrine as that relates to state and federal bargaining in the new and existing programs. And the subject basically, I think, is the cooperative federalism. She also, I should mention, clerked for Judge Browning at the Ninth Circuit Court of Appeals. And of course, Judge Browning is a very, very esteemed and honored graduate of the University of Montana Law School. And then the third speaker is going to be Abigail Moncrieff, and she's seated right next to me. She is an associate professor at Boston University. She teaches legislation, health law, healthcare reform, also teaches on the Constitution, and she has written extensively on the subject of federalism, constitutional law, healthcare reform, and has published in a number of journals. I think the particular aspect of her studies examines the uniqueness of healthcare and health insurance and the regulatory role that it plays in the healthcare market. I think she had the distinct privilege of clerking for Judge Sidney Thomas on the Ninth Circuit Court of Appeals. And in addition to that, she was a legal advisor to the Massachusetts Health Information Technology Council. She was an academic fellow, or perhaps is, an academic fellow at Harvard Law School's Petrie Flom Center for Healthcare Policy, a Fulbright scholar, and she's researched health policy for, I think she spent a year in Geneva, Switzerland. And she is going to talk about the difficulty of enforcing spending conditions against the states after the Sebelius case and predicting and evaluating crowd-out methods of enforcement given the constitutional problems with financial enforcement after the Sebelius case. And then finally we have Anthony Johnstone, who's a professor here at the University of Montana. I've had the pleasure of working with Anthony and participating in some classes where he has been a co-teacher and participant in the classes. He clerked for Judge Thomas some time ago, and then after clerking for Judge Thomas, went to work for Cravath and Swain, and then when he was returned to Montana, he was at the he was the Solicitor General for the state of Montana, and when he was acting in that position, I had a number of occasions to have him as a litigant in front of the court that I was presiding on. And I know that he has been involved in a number of high-profile cases in the field of constitutional law, including the right to die, same-sex marriage, and I think the one that probably grabbed his attention most was campaign finance law. He's going to, in typical Anthony Johnstone fashion, not explicate, but he is going to challenge or complicate the court's principle of political accountability that's set forth in the Sebelius case. I think the Chief Justice made a number of references to political accountability and how that might fit in with the notion of federalism. And I think Anthony's view is guided somewhat by his view of state constitutional politics. And in particular, he's going to talk about the Medicaid issue and how that is, what the consequences are with state attorney generals, the Congress, and state legislatures. So with that, I think that we are going to begin the process, and we'll conduct this panel the same way that the others have been done. There will be roughly 10 minutes for each of the presenters, and then we'll see if we can get an argument going. So, Professor Somin.
I'd I'd like to start by thanking the University of Montana Law Review for organizing so many excellent panels, and all of you for attending the conference today despite the excellent weather and views outside, which in some ways are much more fun than hearing about technicalities of constitutional law. I think it's interesting that on this panel about NFIB versus Sebelius, I think I'm the only one who's actually going to be focusing on the individual health insurance mandate part of the case. I was actually involved in the debate over this while it was being litigated. At that time, almost all of the attention was on the individual mandate part, and I actually wrote some blog posts where I protested this. I said, well, they should pay more attention to this Medicaid issue. So I'm glad that since then that has happened, but I am still going to talk about the individual mandate because somebody has to talk about it. You can't really have a panel on NFIB without including this issue at least to some extent. And my presentation, unusually for me, this is the one part of my scholarly work that is focused on the interpretation of a single word, the word proper. Initially, the federal government argued primarily that the individual health insurance mandate, which at least according to the text of the Act was supposed to require all Americans with a few exceptions to purchase government-approved health insurance by 2014. Initially, the federal government's main argument was this is permissible under the Commerce Clause. But over time, they also increasingly emphasized the idea that if it can't be authorized by the Commerce Clause alone, it is defensible under the Commerce Clause combined with the Necessary and Proper Clause. And that's where the word proper comes in. So in the first part of the presentation, I'll very briefly talk about the Commerce Clause argument in and of itself, because you have to have that as background to necessary and proper. Then I will talk a little bit about why the Necessary and Proper Clause is actually two separate requirements. In order to be authorized by the clause, it's not enough for the regulation to be necessary for carrying into execution one of Congress's other powers. It also has to be proper. And a regulation which is necessary might still be improper. Then finally, I'll talk a little about why the individual mandate fails this test of propriety under either of the two possible interpretations of proper that we see in the opinions NFIB versus Sebelius. And finally, if we have time, I'll talk a little about the implications of this for the future. I do not quite agree with what the judge said at the start, where he said, well, I think this is the most thorough Supreme Court opinion ever. No, it's by no means the most thorough Supreme Court opinion ever, no, not even close, but it is the most thorough discussion the Supreme Court has ever given us of what the meaning of proper is in a necessary and proper clause. So it does have, I think, a great significance for that reason. So first things first, the Commerce Clause. Originally, and actually throughout the litigation, the federal government most emphasized the idea that the individual health insurance mandate is authorized by the Commerce Clause, which gives Congress the power to regulate commerce among the several states. And right away, just looking at the text of this, you notice two problems with the argument. Not having health insurance is not in and of itself commerce, and also it's not interstate. So it seems to flunk both of the textual tests, and to make a long story short, the precedent in this area has, of course, gone way beyond the text of the Constitution, but even the most expansive precedent, I think, didn't go quite far enough to clearly justify the individual health insurance mandate. Even the most expansive precedent still was limited to regulating some sort of pre-existing economic activity, and not having health insurance, a majority of the Supreme Court concluded, and also many lower court judges, was not in and of itself economic activity. This is a contestable proposition. I'm very happy to debate it, but for now, I'll press on to the Necessary and Proper Clause aspect of the case, because over time, the federal government in the lower court litigation and at the Supreme Court, they recognized that their Commerce Clause argument was beginning to run into trouble, so they said, even if we can't prevail under the Commerce Clause alone, we can win under a combination of the Commerce Clause and the Necessary and Proper Clause. Yes, maybe not having health insurance is not interstate commerce, or it's not economic activity, but it's necessary and proper for regulating things that are commerce and economic activity, namely the insurance industry. And the Supreme Court, since McCulloch versus Maryland in 1819, they have defined the term necessary very broadly as useful or convenient. And I think it's difficult to deny that the individual mandate might be useful or convenient for regulating health insurance markets. It surely has an effect on those markets. It has a potentially a very significant impact, and therefore it could meet the very weak standard of usefulness or convenience. However, the clause is not just the necessary clause. It's the necessary and proper clause. And there's a long-standing principle of constitutional interpretation that we should not interpret provisions of the Constitution to make terms redundant. The federal government's approach to this issue did have essentially the defect that under their theory, proper really would be redundant. In fact, if you look at their brief, even at the Supreme Court level, nowhere once did it even acknowledge the possibility that these could be two separate requirements. They just simply seem to assume that if it's necessary, it must also be proper. In reality, this is not the case, not just because it would render the word redundant, but also because it's contrary to text precedent and original meaning. At the time that the Constitution was being drafted, the word proper was actually deliberately inserted at a later stage of the process. It really was the necessary clause originally, but it was later inserted by the relevant committee. And many of the founding fathers, such as Hamilton, Madison, Edmund Randolph, the first Attorney General, they all recognize that these are two separate requirements, that propriety is an additional test that must be met in addition to necessity. This, I think, is also implicitly recognized in McCulloch versus Maryland itself, where, among other things, Chief Justice Marshall wrote that the necessary and proper clause does not authorize laws which do not consist with, quote, the letter and spirit of the Constitution. Now, of course, a law which doesn't consist with the letter and spirit of the Constitution could still be necessary in the sense of useful or convenient. So I think this part of McCulloch is best interpreted as referring to the requirement of propriety, not the requirement of necessity. Moreover, there are modern Supreme Court decisions before NFIB which also specifically hold that these are two separate requirements. The most famous one is the Prince case in 1997, but there's also Alden versus Maine and a few other examples as well. So the question then arises, if these are two separate requirements, what does the requirement of propriety actually entail? And this is the question that the Supreme Court had never even come close to clearly answering in the first 200 years of its history. It had said on various occasions, laws have to be proper as well as necessary if they're going to be authorized by this clause, but what does proper mean? Well, we don't really know, until that is NFIB versus Sebelius. And in NFIB, you see both the dissenting opinion by the four conservative justices and also Chief Justice Roberts' opinion indicating that the reason why the necessary and proper clause does not authorize the mandate is because it violates propriety, even though it might meet the test of necessity. And there's two different kinds of interpretations of propriety that you see in the opinions. One is similar to one which I actually advocated in an amicus brief that I wrote on behalf of the Washington Legal Foundation and a group of legal scholars, though I don't claim that the justices got this from there. But this is the idea that proper at the very least means that the federal government cannot justify a regulation based on an argument that, if accepted, would give Congress virtually unlimited authority. As James Madison put it in 1790 in a speech that he made about this clause, he said, whatever meaning the clause may have, none can be admitted that would give an unlimited discretion to Congress. And this actually is exactly what the federal government's necessary and proper rationale for the clause actually did. Because what they said is that we can regulate this. Why? Because it's useful to effectuating a regulation of interstate commerce. It has an effect on commerce, and this is true, it does, but the same thing could be said of virtually any other kind of mandate that the federal government could possibly dream up. Consider, for example, the famous broccoli mandate that was much discussed during the litigation. Certainly a requirement that everybody buy broccoli, that clearly has an effect on interstate commerce. It clearly would be useful or convenient to regulating the market in food, so that would be permissible. And the same is true of pretty much any other mandate one can possibly imagine. For example, a mandate that everybody must wake up early in the morning to get to work. That will have an effect on the economy. That will have an effect on people's productivity. That, too, can be useful or convenient. And I can make very similar arguments for pretty much any other sort of law or regulation that Congress might imagine. So the rationale here is one that violates this principle of limitation and therefore violates even a relatively minimalistic definition of what is proper. Now, the federal government tried to resist this sort of conclusion by saying, wait a second, this mandate is actually special. The healthcare industry is special, so we have arguments for this mandate that wouldn't apply to most others. I don't have time to go through all the different healthcare special arguments that were made during the litigation. I have done this in some of my published writings, if you're interested. But here I'll just mention the most commonly made argument of this type, the idea that healthcare is special because unlike with broccoli or most other products, we all use healthcare at some point in our lives. So maybe not everybody eats broccoli, not everybody enjoys it as much as I do, but everybody has to use healthcare at some point in their lives. The problem with this argument is that there's a bait and switch involved. The focus is shifted from health insurance, which is what you're actually required to buy, to health care. And yes, health insurance is one way of buying health care, of acquiring it, but of course a similar bait and switch can justify pretty much any other mandate. For instance, it's true not everyone eats broccoli, but everybody is involved in the broader market for food. Indeed, the market for food is even more difficult to avoid than the market for health care is. You don't have to take my word for it, just try avoiding the market for food and probably you won't last very long in that attempt. And you can use the same kind of logic to justify pretty much any other mandate. Almost any good that you can mandate buying or activity that you can mandate engaging in is part of some broader category of activity that is almost impossible for people to avoid. So if this logic holds with respect to the health insurance mandate, it also holds to give Congress unlimited power. Now there's
unlimited time.
How much
so
time do I
you're going to have to wrap it up.
Okay, so I only have 30 seconds or so of stuff left anyway. The other interpretation of proper that was advanced in the litigation, was endorsed by Chief Justice Roberts, is the idea that the propriety is consistent with incidental powers, which are incidental to one of the enumerated powers, but not great and independent powers, which give Congress a whole new category of authority. And the distinction between these two isn't very clear. It's one of the weaknesses of the opinion, but the basic theory here is that you can use the clause to, in effect, pin a tail on a dog, but not to pin a dog on a tail. And I think the individual health insurance mandate is a pretty clear example of pinning a dog on a tail, because the logic here is that Congress have a virtually unlimited power to mandate anything just so that they could regulate this one market or to facilitate regulating interstate commerce. And this is, I think, adding a dog and not just a tail. I think in the future, whether this matters or not depends in part on how broad is the interpretation of the Commerce Clause. If you can regulate almost anything you want under the Commerce Clause alone, it doesn't really matter what proper means. But if there are limitations on the Commerce Clause, and the court has begun to enforce the limitations over the last 20 years, including in NFIB, then it is going to matter, and therefore the issue may well come up in future cases, particularly as we try to explicate what is a great and independent power and what is not. And on that note, I conclude and very much look forward to discussion. Thank you.
Thank you. And now we'll have Professor Ryan.
Well, thank you again. Thank you, everyone, for coming today. Thank you for the Law Review for having me here. It's such a pleasure to be here, not only because I so enjoy talking about federalism, which I do, but also because this is a symposium to honor Judge Browning. And I am one of the former clerks of Judge Browning, and I was discussing with some of my colleagues over dinner last night that he truly remains an icon in my heart, and I really think in the heart of everyone who ever had the honor of clerking for him, and really the honor of working with him, from the other judges of the Ninth Circuit all the way to the cleaning staff and the kitchen staff in the building, because he was that kind of a person who connected with each of us, and he's very dear to me, and this school and this state was very dear to him, and it's really wonderful to be able to be here remembering him, so thank you for bringing me for that purpose. But to my remarks, My remarks are focusing on the court's newest judicially enforceable federalism constraint, the constraint on the spending power that comes to us from the same case that ILya is talking about, the National Federation of Independent Businesses versus Sebelius case, the Obamacare case of a few years back. And it's an important case because it puts a constraint on the federal spending power that advocates for judicially enforceable federalism constraints have been lobbying for, asking for, arguing for decades. Since the new federalism revival of the 1990s, these advocates argue that unless the spending power was constrained, none of the other judicially enforceable constraints of that era would be meaningful. So the 10th Amendment anti-commandeering doctrine, the 11th Amendment protections for state sovereign immunity, the limits on federal power under the Commerce Clause or Section 5 of the 14th Amendment would all be meaningless because Congress can just get around them effectively by bargaining with the states using the spending power for access to policymaking jurisdiction beyond the other enumerated powers. And so I think it's important to recognize the spending power is just one of many ways that the governments, the state and federal governments, negotiate with one another in these areas of jurisdictional overlap where both sides have some legitimate regulatory interest or capacity and ability to help solve part of a complicated problems. And I suppose I should be using my slides here. Yes, I have my publisher is like ILya's publisher and requires the same, note about my book everywhere I speak. So if anyone has read my book, you know that I actually think that intergovernmental bargaining is a really valuable and important way that interjurisdictional governance is made and kept informed by local and national perspectives. But the spending power has been a big one, and we need to talk about the appropriate constraints of all state-federal bargaining. And so the proponents of judicially enforceable constraints who have wanted the spending power to be reined in will be happy to know that the Supreme Court have come around to that view in the doctrine they gave us in Sebelius. That said, the doctrine itself turns out to be, I think, so weak that it will not impact federal lawmaking quite in the way that those advocates had hoped for. And as I note in the paper on which this talk is based, ironically, that makes it fairly consistent with the rest of the new federalism judicially enforceable constraints. Federal lawmaking has not changed as dramatically as those proponents may have hoped. So in any event, in this project, this project is called The Spending Power and Environmental Law After Sebelius. I set out to understand what this new doctrine was really going to say, what was the shape and the impact of this doctrine, and to help me do that, I tried to apply it to a body of law where spending power bargaining figures very prominently. And that's a body where I have some expertise, environmental law. So what I've done is, in this paper, in this presentation, I'm going to very quickly try to do maybe a shadow of what I do in the paper is the first part of the paper looks at the actual shape of the doctrine. It does some fairly rigorous doctrinal analysis to tease out the factors of this test and understand what it says. And then I just took those factors and I applied them to the entire body of environmental law that includes programs of cooperative federalism to see what would change, what laws would actually be impacted by this doctrine, and what looks different afterwards. And I did this not only because I'm interested in the answer to that question, what does environmental law look like after Sebelius, but because I'm interested in the larger question of what does intergovernmental bargaining look like after Sebelius. And I think environmental law provides a wonderful, we could even say laboratory for analysis for other areas of law, like healthcare law and education law, and other areas that also include a lot of spending power bargaining. So the punchline of the piece is essentially that I conclude very few federal laws will actually change as a result of Sebelius. Very few federal laws are going down because of the new constraint in Sebelius. That said, the dynamics of intergovernmental bargaining may change in important ways because of the factors in this test. And so in my presentation today, from here, I'm going to just very quickly sketch out what those three factors are. I'm going to very quickly kind of give you the result of the overall analysis of what it looks like in this body of law, environmental law. And then I'll conclude with a few remarks about how this might impact state-federal bargaining and whether the Supreme Court has accomplished the goals that it set out to accomplish in the case. So I'm sad that I don't have time to really go into the doctrinal analysis because it's not entirely immediately obvious from the text of the opinion exactly what the test looks like. There's been a lot of scholarly literature trying to make sense of an essentially vague statement in the Chief Justice's plurality decision. Nevertheless, the majority of the scholarly community have coalesced around 3 factors that we think really have to be present before there's a violation of the Constitution under this doctrine. And so the consensus seems to be that for an act of Congress to exceed the spending power under the Sebelius test, 3 things have to all be true. Number 1, there has to be some kind of an ongoing spending power partnership in which the states have formed reasonable reliance interests and are therefore, subject to unfair surprise if there's some kind of a change. Number 2, there has to be some kind of a change that conditions funds within that entrenched program on some new condition that's not directly related to how the funds are going to be used. And number 3, the funds at issue have to be so large and the threat or the impact of losing them on the state, that threat so big that the state's capitulation to the new terms really reflects coercion, not consent, meaning the states feel kind of trapped. They're afraid to lose this money, and therefore they're not bargaining freely the way that we anticipate both parties to a bargain to be doing for that bargain to really be legitimate. So these 3 factors leave open a lot of questions about the limiting principles of the doctrine. Very quickly, we get that there's coercion if the size of the grant and its intersecting conditions somehow make refusal practically impossible by the states. However, we really have no idea from the opinion itself the 2 limiting principles. How big is too big? When is a grant sizable enough to trigger scrutiny? All we know from the opinion is that the grant in South Dakota v. Dole was okay, and that was a grant for less than $1 billion or less than 0.05% of the state's annual budget. That was okay, but the grant in the Medicaid expansion, $233 billion, or up to 10, maybe on average 10% of a state's budget, was not okay. But that's a pretty big range of uncertainty where we really don't know. There's a lot of lawmaking in the middle of that. We don't really know where the line is of coercion. More importantly, we don't really know from the opinion what kind of a crossover condition would trigger the doctrine. So what exactly is an independent condition that's making the states do something with the money different from what was there before. So, for example, when Congress changes the law, is it just an amendment, as Congress characterized the Medicaid expansion at issue in the Sebelius case, or is it an independent program, as the Chief Justice characterized the Medicaid expansion? There are no tools in the doctrine, no tools in the opinion that really help us do that work. So there's a lot of uncertainty. In the paper, I discussed the possibility that there are also some problems of workability in the implications of this doctrine. For example, after the case, there are now 2 tracks of Medicaid regulation. There's the Medicaid expansion that Congress wanted all the states to get on board with, and now there's the original Medicaid that's been preserved for the states that did not want to join that. But what that leaves us uncertain about is what happens if Congress maybe learns from its experience over the last couple of years and modifies Medicaid again. Do we then have to have 3 tracks of Medicaid for the original Medicaid, and then the Medicaid expansion Medicaid, and then the new amended Medicaid? Will there have to be 4 or 5? It's completely unclear how that would work, and I raised the possibility that perhaps the saving grace of the vagueness of the opinion is that it will ultimately be confined to its own facts, becoming, we could call it the Bush v. Gore of spending power jurisdiction, really only limiting Medicaid. But as Abby and I were talking about, that's a big limit. Medicaid is a big deal, so it's not unimportant either way. Now, I took these factors, nevertheless, as best I could, and I applied them to all of environmental law. Every program, every environmental law that includes some program of cooperative spending, cooperative federalism, and I'm using slides specifically so I don't have to read them all. I just think you can kind of get the picture of what list we're looking at. I took those factors, I saw what changed. Just to remind you, we're really looking for 4 things. First of all, it has to be about the spending power. Second of all, we need that ongoing spending power partnership that creates state reliance. Third, it has to be that the grant at issue is so big, loss would affect coercion. And fourth, there has to be this crossover condition that ties the existing money to some independent term. And I'm now going to show you a horrendous slide, but it's the best visual I can give you to see what this looks like when applied to a standing body of spending power law. So this is the answer to the question of what environmental law looks like after Sebelius. And I'm just going to quickly kind of tell you by color coding what I found, and I think it's probably representative of what a lot of areas of law look like under this doctrine, which is at the top in blue, some areas of cooperative federalism that are untouched entirely because they don't involve the spending power. Cooperative federalism doesn't require the spending power. In green, there are a number of environmental laws that do involve the spending power. They do engage state and federal partnerships using the spending power, but only for one-time grants. Grants that can't really be construed to create an ongoing reliance interest on the part of the state. Number 3, in yellow, there are some laws that do have ongoing spending power partnerships that could create reliance interests, but the amount of money at issue is much smaller even than the Dole threshold of safety. So they don't trigger the second factor in the Sebelius analysis. Number 3, in orange, there are some environmental laws that get closer. There's an ongoing spending power program. The amount of money is big. It's in between those two points of reference we have in the opinion. It's somewhere between Dole and Sebelius. But they don't have that last factor, the crossover condition. In fact, in all of environmental law, there's only one law that potentially triggers all 3 factors, and it's the Clean Air Act. The Clean Air Act has a provision in Section 179 that allows EPA to withhold highway funds from states that fail to prepare or implement an air quality management program under the Clean Air Act. This has the potential to violate Sebelius. It's an ongoing program. The Department of Transportation had been administering those funds since 1956 or 1959, a long time before the Clean Air Act. The amount of money is big, $62 billion. It's squarely between the 2 guideposts we have in the opinion. And number 3, it has arguably a crossover condition. It requires states to do something, prepare air quality management plans separate from the money that's designated to build highways. Now, it's interesting to note that this condition satisfies the previous spending power constraints under Dole. It satisfies the germaneness constraint because the use of those federal highways is material towards air quality problems within the state, and Congress could have wanted to fund highway building in a way that would not make air pollution worse. And so it's been held okay under Dole, but Sebelius changes that because Sebelius requires a closer relationship, or it appears to require a closer relationship between the constraint on the funds and the use of the funds. The funds are for building highways. The air quality management program is not. Now, in the paper, I then proceed to defend vigorously why I nevertheless think that the Clean Air Act would survive Sebelius scrutiny. And it has to do, and it's important to just mention it because I think more laws will be like the Clean Air Act than Medicaid. One of the reasons is that the amount of money at issue is going to end up being much smaller. 2, the EPA actually has a lot more discretion about when and whether and how to sanction, much more than the all or nothing penalty that was created in the Medicaid expansion. But most importantly, the Clean Air Act includes a federal fallback position that I understand the drafters of the Medicaid expansion now rue that they had not done. The federal fallback position being, if the states don't want to do this and they don't want to suffer the penalty, they can effectively opt out by allowing the EPA to create a federal implementation plan, a FIP alternative. By doing this, they remove themselves from this terrible choice of losing the existing funds. And since the purpose of Sebelius is to avoid coercion, this should survive because the state has a choice between alternatives, one of which at least is clearly constitutionally acceptable. Now, with all that in mind, I still think we need to think about the impact of the doctrine. So I conclude, coming back to my conclusion, I'll just go here so you don't get distracted reading busy slide. At the end of my paper, I conclude that even though it's a weak doctrine, it's not very many federal laws are going to trigger it, and that's going to be disappointing to new federalism proponents who wanted more from the doctrine. It still has the ability to shift the dynamics of intergovernmental bargaining in important ways because it gives leverage to the states at the state-federal bargaining table where a lot of cooperative federalism takes place. The doctrine is basically a constraint on federal lawmaking that didn't used to be there. The federal government can do less, and more importantly, the federal government has to consider the possibility that it will have to defend or justify what it does do. That's leverage for the states, because anything that makes it more difficult or more expensive for the federal government to understand its own jurisdiction turns out to be leverage for the states, and we know this from the analogous environmental context of wetlands regulation after the court's decision in Rapanos, which made much less clear the scope of federal jurisdiction over wetlands, and as a result, federal enforcement under the Clean Water Act plummeted, even in realms where federal jurisdiction was probably there, just because it was too costly for the federal government to have to prove it on a case-by-case basis. So it's quite possible that Sebelius has the potential to weaken enforcement under the Clean Air Act and other laws. That said, I think it's important to recognize that it's not clear that the constraint is really doing what the Supreme Court wants it to do. Because I think we can probably all agree that the Supreme Court wanted to do something that was going to help empower the states. The plaintiff states in the Medicaid case felt that they didn't have enough power to bargain meaningfully over Medicaid. The thing is, this leverage only works for the states if the federal government has to bargain. And as Justice Ginsburg pointed out in her dissent, one unintended possible consequence of this change is that the federal government will retreat from spending power bargaining and replace it with versions of federal fiat, even in arenas where states might prefer to be consulted, even in just the medium of spending power bargaining. So that's kind of tragic for everyone in that the Supreme Court didn't quite get what it wanted. It might not be good for states who might actually be crowded out, as Abby will talk about, of realms of interjurisdictional governance where they had been consulted, at least in some more limited form. And at the end of the day, I think it's bad for interjurisdictional governance, which does best when it does consult both local and state and federal perspectives. So we'll have to see where things go, but I'll end my remarks with that.
Thank you. Professor Moncrieff.
All right. So that teed me up quite nicely, which is good. I'm going to actually complicate things even more in this incredibly complicated area. So I'm going to introduce another case to the puzzle, actually two more cases to the puzzle. So we have this really, really common structure in American federalism today that we call cooperative federalism. And it involves a lot of what Heather Gerken and a co-author, Jessica Pullman-Posen, called uncooperative federalism, when the states actually resist national directives within cooperative federalism programs and do so in a variety of ways. And this raises a question of what happens if a state just outright refuses to comply with one of the conditions on a national grant to the state. So if a state just says, well, I can't afford to or I don't want to comply with this aspect of the cooperative federalism program, then what? So it turns out that the then what answer is really, really complicated because the Supreme Court has made it messy. In a line of cases from Pennhurst to Gonzaga University against Doe, the Supreme Court had to ask the question and answer the question of whether individuals who are harmed by state violations can sue the state agency to enforce the spending clause condition using Section 1983, which is a private right of action for state deprivations of federal rights. So the question is a spending clause condition a federal right that individuals can enforce through Section 1983 actions? And the answer has been, from Pennhurst to Gonzaga, basically no. Individuals cannot sue to enforce. There's some exceptions, but for the most part, no, individuals cannot sue to enforce spending conditions. And in Pennhurst, the court said explicitly, in legislation enacted pursuant to the spending power, the typical remedy for state noncompliance with federally imposed conditions is not a private cause of action for noncompliance, but rather action by the federal government to terminate funds to the state. Okay, so the Supreme Court says the only way to enforce spending conditions is for the federal government, the national government, to take money away from a state that is refusing to comply with spending conditions. So then, fast forward, a bunch of individual litigants try to work around this limitation on Section 1983 by suing directly under the Supremacy Clause, and that gives rise to a case in the Ninth Circuit called Douglas against Independent Living Center of Southern California, in which the Supreme Court gets utterly confused by the procedural posture of the case, and Justice Breyer, in an opinion that's probably not precedential, ends up urging litigants, instead of using the Supremacy Clause and private litigation, to sue federal agencies for failing to enforce their own statutes, their own spending conditions, using the Administrative Procedure Act. So Justice Breyer says, bring APA challenges against federal agencies when they don't enforce spending conditions against states, and we, the courts, will force the federal agencies to enforce their federal statutes. Okay, so let me make this a little bit more concrete by telling you about the actual program, and it happens to be Medicaid, so it ties in perfectly with NFIB against Sebelius. So in Douglas, what was at issue was a provision called the Equal Access Provision, which requires state Medicaid programs to pay doctors at a rate, to reimburse doctors for their services at a rate that is consistent with efficiency, economy, and quality of care, and sufficient to enlist enough providers so that care and services are available under the plan, at least to the extent that such care and services are available to the general population in the geographic area. What that means is that rates have to be essentially the same as Medicare rates. Medicaid rates should be essentially the same as Medicare rates. And that's the way that most courts have interpreted that really long provision. So, the state of California had cut rates to below the Medicare rate, significantly below the Medicare rate, and CMS nevertheless approved the state plan with the new lower rates, seemingly in violation of the federal equal access provision that's part of the Medicaid Act. And so Justice Breyer said, well, sue CMS under the APA, say that it was arbitrary and capricious for CMS, that's the Centers for Medicare and Medicaid Services, for CMS to have approved a state plan that so clearly violates the equal access provision. Okay, so now put that together with NFIB against Sebelius, which says quite clearly that CMS is not allowed to use its one and only enforcement tool, which is the withdrawal of Medicaid funding, for any condition of the Medicaid Act that is new since the states joined the program to such a degree that it's a different kind of program or something along those lines. And we're not sure what counts as a new program and what doesn't. That's the vague part that Erin is talking about. So we don't know which provisions of the Medicaid Act are going to be enforceable through withdrawal of funding and which ones aren't. We know for sure that withdrawal of all of a state's Medicaid funding is a really, really big deal, and is such a big deal that the 4 dissenters in NFIB thought that it would be coercive for CMS to withdraw funding, even for violations of provisions that have been part of the Medicaid Act from day one. So we have this really weird direction coming out of the Supreme Court, all in October term 2011, saying litigants sue CMS. It's CMS's job to enforce its statutes against the states. But CMS, you can't enforce your statute against the states because that's unconstitutionally coercive. At least you can't do it through the only enforcement tool you have, which is the withdrawal of federal funding. So my prediction from this set of cases is that financial enforcement tools are going to get really hard for CMS to use. And I agree with Erin that states are going to be in a good bargaining position to be able to say, hey, we can't comply with all of these federal requirements. It's too expensive. We don't have enough money. It's too hard. We can't really run our Medicaid program up to the standards that you in Washington have set. And you can't enforce your statute against us anyway because it's unconstitutional for you to do so. And they're in this heightened bargaining position. But CMS is in a really tough spot because now it's going to have to say back, well, if we don't make you abide by the Medicaid Act requirements, then we're going to get sued under the APA, and then what? So there's this odd horizon that we're approaching, where Medicaid is simultaneously must be enforced and can't be enforced, and so this regret that Erin referenced, that Congress did not put in an alternative enforcement tool of a federal fallback option, is, in my opinion, what we're going to move in the direction of. And I agree with Erin in saying what we're going to see, probably, given this set of cases, is that spending conditions will become enforceable only through conditional preemption or crowd out or federal fallback, whatever you want to call it, where if a state can't or refuses to comply with spending conditions, federal spending conditions, the federal government will simply take over the program from the state, which is clearly constitutional for it to do. So then the question is that a good thing or a bad thing? I think in one sense it's clearly bad. The Supreme Court wanted with the NFIB doctrine to improve states' rights, state sovereignty, state power, and I think that the rule that it set is going to backfire with respect to that goal. However, I will sort of stand here as the probably most pro-federal power person in the room. And afterwards, ILya will take me outside and beat the shit out of me for saying this. But I think that it's probably a good thing to have the federal government take over Medicaid. So let's think about what the values are. Okay, oh, there you go. All right, so let's think about what the values are of national governance, what the values are of state governance, and what the values are of cooperative federalism. I think it's likely that the national government can do a better job of maximizing value in these programs than either cooperative federalism or purely state governance. So the values of national governance that we typically talk about are uniformity, economies of scale, prevention of spillovers or externalities among the states, and the ability of the national government to spend countercyclically and redistribute among the states. The values of state governance that we usually talk about are experimentation, diversity, voice, and exit. ILya gave a great presentation on the value of exit and voice in his keynote last night. And the value of cooperative federalism is that it manages to sort of combine these values. The national government can, through its spending conditions, create some uniformity, create a national floor of regulation, but allow for experimentation, diversity, voice, and exit above the floor by allowing some differentiation among state programs. The financial enforcement tool, if it ever had been used, which it actually hadn't been, but if it ever had been used, would have reverted to pure state control any program that the state couldn't enact through the cooperative model, right? It would have said, okay, we're taking away all of your national money, but now you're in charge of health insurance for the poor or of environmental regulation, you the state. It would have been a devolutionary move. Whereas crowd out is the opposite. It says, okay, now the national government is going to take over this policy regime, but the national government takes over only in the state that has failed and continues to allow other states to play above the national floor if they can. Let's imagine that every single state failed to comply with Medicaid Act requirements and the national government went in and took over each state's Medicaid program individually. It's possible that under that kind of regulatory scheme, the national government could have different policies in different states, which might allow for the same kind of experimentation, diversity, and exit that we like out of having states be in charge. But voice would not be able to be preserved. So the value of voice depends solely on the number of constituents per representative. And if Washington is in charge in your state, it doesn't matter whether Washington is doing the same thing in every state or is doing different things in different states for your ability to influence what Washington is doing, right? Because your national representatives have the same number of constituents either way. Okay, so it may be that having crowd out actually does a better job of balancing national and state values, the values of federalism, of each government being in charge, than financial penalties for failure to comply with Medicaid Act requirements or spending clause requirements of any kind. That's my assessment anyway, and I'm sure that others will disagree with me. But the bottom line, I think, is that the Supreme Court, with the combination of Pennhurst to Gonzaga to Douglas against Independent Living Center, and including, by the way, its failure to limit the spending clause generally under Butler and Helfering, which are pre-New Deal cases, the Supreme Court has just created this very odd situation where in the name of trying to protect state rights, it has probably driven Congress to do more nationalization of policy and to take over policy regimes from the states more than it would have otherwise. So it's a little bit perverse and inverted from what the Supreme Court probably wanted, but I think ultimately it's probably going to be a good thing, unless the Supreme Court figures out that it messed up and fixes it, in which case then it might get worse again. Okay.
Thank you. Professor Johnson.
Thank you, Judge. Can you tell that I'm a Mac and not a PC? Most of you already know that. Great picture, great motto. Thanks, Law Review, for doing this. What an incredible job, and I'm just happy to be a part of it. It does end up a snake. And note also that, so I believe Benjamin Franklin first printed this actually in pre-revolutionary times. And note also that it links all the New England states together right there at the tail. What I'm going to talk about how a state is a they and not an it for purposes of this. And this harkens to several other articles that have been written on Congress is a they, not an it. The Supreme Court is a they, not an it. Even the executive is a they, not an it. What I'd like to do, and I guess as Judge Molloy proceeded, and as of course all of my students already know, is complicate things. But I'd like to complicate some of these theories with practice. What actually happened? What were the Supreme Court's suppositions in freeing states of this unconstitutional coercion in the healthcare cases? How'd that play out? How'd that play out? And I guess where I start, as Professor Somin started as well, you really can't go wrong with McCulloch. But starting out with this basic principle. Now, this is in the context of the ratifying conventions to the Constitution in response to Maryland's argument that no, the states were acting as states and therefore that they are uniquely sovereign in response to whatever preemptive power the Bank of the United States might have. But Chief Justice Marshall's response was, of course, we're not talking about compounding the American people into one common mass, but when the American people speak, they speak in states. But they do not always speak as states. They have several voices as a state. Montanans speak through our congressional delegation. Montanans speak through our state legislative races, and Montanans speak through multiple executive elections. Unlike the federal government, we have a divided executive. So we speak through electing our governor, but we also speak through electing our attorney general and other statewide officials. So what I'd like to talk about is sorting out, tying together some of these threads of federalism that we've been talking about today in the Medicaid expansion, and then asking this question as we look at that picture, also look at it from the state side. Who is this state that the court is talking about? It's actually several voices, and I don't think the court's been sufficiently attuned to that, particularly in the way it discusses this question of political accountability. And so that's what we're going to look at, let's look at the different ways in which a state speaks. Let's check that against the principle of political accountability that the court announces or reiterates in the healthcare cases, and see whether practice confirms that idea of cleaning up political accountability. So this, of course, the story of the healthcare cases. I should say, in terms of tying this all together, we've had lots of different versions of federalism coming in, and I don't think Abby's complicated it too much in terms of introducing this cooperative federalism angle, which of course was the subject of Erin's discussion of environmental law too. That's a big piece of it. There are really kind of three kinds of federalisms going on. We have the sovereign version of federalism, which is the idea of limited commerce power. It was the version we saw this morning with Justice Thomas's view of ICWA as limited. But we also have a couple of other views, not just dual sovereignty, but a couple of more complicated views. We have the process theory view of federalism, the view that was ascendant in the Garcia case, where the court says, we're going to talk about the political safeguards of federalism, and that should be enough to protect federalism. The negotiation, think about medical marijuana, right? That is a question. The federal government has a claim to completely overlap and override drug enforcement policy in that area. If you're going to get out of it, look to Justice Nelson, right? It's going to be a question of negotiation and the states speaking within the federal political system. And then finally, we have the cooperative federalism that we see in conditional spending, conditional preemption that we see in environmental law, and several other areas. The healthcare cases, in particular, the Florida side of this case, the one brought by the states involving the Medicaid expansion, involves all of those. It involves political process federalism in the state attorneys general and the legislatures speaking on behalf of their people, passing laws declaring that the health care law was unconstitutional, electing attorneys general who will go and bring the federal government to court and sue. Right? That's a political process. They're speaking within the federal system, including the federal courts, objecting to the health care law. But yet there are also aspects of sovereignty, of dual sovereignty federalism, where, of course, if they win that, they could invalidate, right, the entire healthcare system, the entire healthcare laws being inconsistent with the commerce power, for example. They didn't because of the taxing power, but that's a possibility. That's a possibility. They can exercise sovereign powers as well as their political voice, the political process. And finally, right, what the solution the court came to was a cooperative federalism kind of improvisation, I guess, might be the way to put it, in terms of, okay, now we're going to give the states the opportunity to have an option that Congress actually never gave them. Why did it do that in the healthcare cases? Well, this is the Medicaid spending condition. The Secretary can yank the funds if a state is out of compliance, and being out of compliance would be not expanding it. Why would the court be concerned about this idea of we're going to yank all your Medicaid funds? Well, as the court famously said, this is like a gun to their head, and permitting them to force the states to implement a federal program would threaten the political accountability key to our federal system. Now this is not a textual argument. It's actually it's unrelated to the original meaning of the General Welfare Clause. We have Professor Renz, who's written on these questions. In terms of it, it's at best a structural argument, like in McCulloch, but it's also just kind of firmly grounded. It's a policy call. It's this idea that it's a political science judgment that political accountability, which is a good thing, will be enhanced by giving states a choice whether to participate in these federal programs. And based on that, in order to make sure that voters know who to blame and who to credit for their policies, they said, this is too confusing. They're not going to understand in the Medicaid expansion, this is going to confuse the voters. And so, because this isn't a Mac, I wasn't able to use all my fonts. I try to use Comic Sans whenever the Supreme Court rewrites federal law, but that's the red part there. Right? So it amends the law and says, okay, we're going to give the state an out. That's what happened, and it did it on the basis of this accountability principle, that's what the spending power, consistent with a view of structural federalism, requires. That's how it's limited. So states can choose, and the court explains states are now going to choose, everything's going to be great. States have retained this sovereign, in some way, power to opt in and out. They can either cooperate or be uncooperative from the system. That's the system. They can be quite uncooperative because if they don't expand Medicaid, that actually might compromise some of the actuarial soundness of the entire bill. So what actually happened? And this is kind of the real kind of focus and thought. In practice, what happened? Well, what I've done here is taken the states and mapped them on two axes, and to understand that the states have multiple voices. The states are they. The one axis says are the states whose executive branches said sue, and the others whose executive branches said don't sue. On the other axis are the ones who said, okay, once they're given the choice by the healthcare cases, expand Medicaid, and the others say don't expand. And what's quite interesting about it when you map it out is they're actually all over the map in terms of this. You have as we go through it, 4 different categories. And there are actually quite a few states and different stories about these different voices within the states interacting in each of these cases. So you have the quote-unquote winners. You'll see why, I'll tell you why I put them in quotes. Maybe there should even be scare quotes. But the winner states. The winner states are mostly red states whose congressional delegations didn't like the Affordable Care Act anyway. And so their executives, generally their attorneys general, but in the italics, actually it was not the attorneys general, it was the governors purporting to sue. Never quite clear that they had standing to bring that case, but generally the attorneys general. Virginia and Wyoming, or in Wisconsin, quite active attorneys general, out in front of their congressional delegations, arguably, or maybe behind, right? We'll have to see. But they took a position contrary to their congressional delegation. They won. They didn't have to expand. They're not going to expand. They brought the lawsuit. They won. You don't have to make us expand. Now, here are the losers also in scare quotes, because what's the resolution for them? They didn't want to sue. They loved the law as it was, and it lost. So are they in bad shape? Well, actually not at all, right? Because now they are expanding, and the Supreme Court has ensured that the winners will cross-subsidize the losers through their taxes, right? Because that's just how the spending power works. The winners are still paying taxes, right? And the losers get to spend it. So not really losers, and arguably maybe the winners aren't really winners in this case. These 2 other, again, Kentucky, worth asking these state con law questions. Kentucky, why is a red state doing it? The Kentucky Attorney General is appointed by their Supreme Court. Right? So different story of accountability, one the Supreme Court would never get into, but different kinds of accountability at the state level. The 2 more interesting ones are the choosers whose attorneys general, generally, although not Iowa and Nevada, again, those were governors, the attorneys general refused to sue, where they sued, but then the legislature went and said, okay, well, we won that, we have a choice, now we're going to exercise that choice. And of course, the Chief Justice in his opinion said this, they can exercise that choice. They get to choose. In some ways, they're like the quote-unquote losers, right? Where they sued, they're actually quite clever in this way, where they sued, got it struck down so none of the winners would expand Medicaid, but then they slipped in afterwards and say, oh, we're going to expand anyway. We like this program, particularly now that those winners are paying for us. Indiana and Utah still up in the air, right? They're trying to, this is a pretty sweet deal for them, trying to figure that out. The final one, and the one that actually causes me some concern are, and I just picked non-movers because it rhymed with the other ones, but they're the ones who sat it out. Missouri, Montana, North Carolina, and Tennessee. So I'm sorry, Kentucky actually does have an elected attorney general. Tennessee's is appointed by the Supreme Court. Well, what happened there? This is the one that kind of causes me the most kind of constitutional politics heartburn. Those states did not sue, and yet they had a legislature that has not decided to expand. What worries me about it is that those executive races, in some ways, to some degree, got hijacked by federal policy. In other words, in those races, including in Montana's, the attorney general races turned in an important respect on whether Obamacare was a good policy and whether the AG should sue to do that, thus displacing state politics, right? They were talking about what their congressional delegation already did here in Montana, what, in fact, in quite a big way with Senator Baucus, rather than talking about issues before the state. And that might be a concern that actually confuses political accountability. So that's kind of the puzzle I want to lay with, is if we're really about political accountability, is the resolution here, is what's happening here in bringing federal politics into state legislative and state attorney general races, is that really the best way to clear up accountability? Because now suddenly we're being asked to hold our federal government accountable by voting for our state attorney general, or holding our federal government accountable by voting for our state legislature and passing a nullification law. That may not be the best kind of accountability in terms of particularly low salience state elections. So again, this is the accountability principle. I just want to end to go back to ILya's point about political ignorance. This is just too easy coming from Montana, of course, is, should we expect the justices to be great political scientists? Well, Well, I think not. They no longer have any state elected officials on there, so there's no direct experience of accountability after Justice O'Connor left the court. And yet we have people who are quite steeped in the culture of Washington, D.C., whichever political party they're associated with. That is probably not a recipe for a sophisticated view of political accountability. And yet that may be what's required, given that the states are theys, not its. Thank you.
Thank you. Thank you to all of the panelists. If we were in the federal court, up on the bench, there are, from my aviation days, there are 2 clocks, one for plaintiffs, one for defendants. And it's a stopwatch. And so when I say you get 10 minutes, I turn it on, and at 10 minutes, I say your end. The comments all were so interesting, it seemed probably inappropriate to be stuck with time limits. But we're getting close to, I think, the end period. I just have a couple of questions, and then I thought we would open it up to those of you in the audience who probably have much more insightful questions. But as I sat here and listened, we're talking about federalism, which is easy to define in one sense. Well, it's the federal government and the state government. But I've heard now cooperative federalism, comparative federalism, collective federalism, fiscal federalism, preemption, statutory federalism, judicial federalism, structural federalism, and identity federalism. So my general question to all of you on the panel is, what are we talking about when we're talking about federalism? All of those things, or is it really just simple, state versus federal?
I think we're talking about all of it. I think it depends on the context, right? So like in NFIB, I think our primary concern was cooperative federalism, because we were looking at a statute that's clearly set up in a cooperative federalist structure. And what we worried about was whether the national government, through fiscal federalism, had gained too much power over the states within a program of cooperative federalism. Right? So I think it all goes together. It's all interrelated.
Sure. I mean, yes, there are many different concepts of federalism. Federalism is like freedom, justice, equality, one of these terms from related to constitutional law that can mean many different things. I think the only solution for that problem is to be precise when we're talking about particular issues. But I do think they all at some level have to do with the relationship between the federal government and state and local governments. It's just that that relationship has many different dimensions, and the best we can do is try to be clear about which of those dimensions is the one that we're actually talking about in a particular situation.
Anthony, do you think the court does that?
Yeah, I mean, maybe in too many different ways. I guess I think that the way that we've, of course I think the way that law professors talk about federalism is a correct way. But I do think there is something to the distinction, and definitely some, for purposes of thinking about federalism, worth noting that in fact the Constitution itself contains several different views. Some are based on dual spheres, sovereignty, where there's simply two different areas. Some things are local, some things are national. That's dual federalism, the sovereignty-based. But there are also, such as the Elections Clause, dealing with the time, place, and manner of elections, quite explicit provisions that say, well, this is federalism where the states can control it, but there's direct preemption power, actually even written in, not even just as a matter of the Supremacy Clause. So it is, I think, as ILya says, it's worth paying attention to which part of the Constitution you're working with and being clear about how exactly that's working. Is it operating through preemption? And then a process-based federalism where states will exercise voice, or is it working through some sort of sovereignty determination and a dual federalism model where states have this sovereignty to say, no, you can't touch us?
So I have a question for Professor Ryan and Professor Moncrieff. Given the positions that you've laid out, what's the significance, if any, now of South Dakota versus Dole, which is where the federal government said up the drinking age to 21 or you don't get federal highway money. So does it have any viability?
Yeah, I think South Dakota against Dole is still good law. It's preserved in Chief Justice Roberts' opinion in NFIB pretty explicitly. And I think as Erin laid it out, I agree with the way Erin laid it out, where what we have now is a lower bound and an upper bound of our uncertainty. So we know for sure that 0.05% of a state's budget as a penalty for noncompliance with national policy prerogatives is an acceptable penalty to impose. So if you take a state from its baseline and you bust it down by 0.05% of its budget for its refusal to implement a national policy, that's fine. That's not coercive. That's just an incentive. But if you bust it down by 10% of its budget, then that's coercive and not fine. And so then the question is, where's the line in between? And Chief Justice Roberts goes out of his way to quote Stewart Machine and say, we don't have to draw a precise line here, so we're not sure. So I think South Dakota against Dole is still good law, notwithstanding NFIB, but it's just going to be what puts the states in a good bargaining position with respect to enforcement of spending conditions is that we don't know where the line is in between the 0.05% and the 10%.
Erin?
I don't have that much to add to what Abby said because I agree with it. And by the way, I just have to say this because it may never happen again. You know what ILya just said? I agreed with everything ILya said. There, I just wanted to have that on record. So the only thing I would add to what Abby said is that I think it is interesting in the, and Justice Ginsburg in her dissent, I think, also noted this somewhat ironically or piquedly in one of her footnotes. The Chief Justice's plurality opinion does not go to great lengths to build around the Dole opinion. It does go to great lengths not to overrule it. Clearly, it was a priority of the court not to displace the many decades of spending power jurisprudence and federal lawmaking that had been approved under Dole. There was no desire to do that. But it was perhaps surprising that Dole, being the most important spending power precedent to date, was not better engaged in the opinion, and the opinion didn't go to great lengths to try to exactly explain to everyone how the two were going to work together. And that suggested to me and others that there was two compelling political desires that were functioning behind the opinion. One was to not displace and upturn all of the settled federal lawmaking that had happened to this point, but two, to do something different that was very hard to harmonize with Dole, except by saying, and the only way that Dole is differentiated is that there just wasn't enough money at issue.
All right. I have a question for Professor Somin, and I'm going to read you something, and this is not an argument that was made at the court, but in light of the things that we've discussed today, and in particular with the notion of structural federalism, and as I understand that, there is, of course, the vertical component of the states versus the federal government and what authority is there, and then the horizontal component, which would be the separation of powers issue, as that's usually called. But Akhil Amar, in talking about the necessary and proper clause, takes, I think, and I may be wrong about this, but a little different view than Chief Justice Roberts did, and apparently the one that you hold. And he said the delegates did vest the Congress with sweeping power of a different sort in the final clause of Section 8, and that's of Article 1. Anti-federalists fretted about the threat to states' rights posed by the words empowering Congress to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. In response, the Federalists repeatedly explained that these words did not constitute some free-floating grant of near-plenary power. Rather, the clause merely clarified that the rest of Article 1, Section 8, should be read at face value, while the Articles of Confederation had proclaimed that Congress had only the powers, quote, expressly, end quote, granted by that document. Article 1 pointedly avoided this stingy word. The new Congress would thus have all powers listed in the document and also anything that followed by fair, commonsensical implication. And he goes on to talk about how that may be applied. But why isn't the word proper defined within the structure of the Constitution? And that is that it's the Congress that says what's power, what is proper, so long as whatever they're regulating is impacted by one of the other articulated powers in Article 1, Section 8.
So there's really two questions there. One is what I said consistent with what a QMR wrote in that passage? And second, is a better view than what I said, something like that Congress gets to define what's proper as long as there's some connection of some sort to one of the other powers. Although a QMR and I disagree very much about the results in NFIB versus Sebelius, I actually agree with that particular passage in his writings, and I even quoted it in my article on this subject because he specifically says it's not a grant of plenary power. Indeed, in that passage, he takes a more limited construction even than I do because he just says, well, all this means that we mean what we said when we granted the other powers in Article 1, Section 8. And so it means, therefore, yes, you absolutely can regulate interstate commerce, but of course, regulating interstate commerce is not the same thing as regulating anything that might conceivably affect interstate commerce in some way. And as to the reason why I would reject your second point that Congress gets to define what's proper so long as it's regulating something that's in some way connected to one of the other powers, the problem is that that interpretation does in fact grant Congress plenary power because almost any kind of mandate or regulation that Congress might pass might be considered as something that affects interstate commerce in some way or something that affects one of the other enumerated powers of Congress. So I think the way to reason this is that at the very least, proper means that this sort of move is barred, a move that allows Congress to regulate anything that it might in some way affect something that could be regulated by one of the other enumerated powers. More could be said on this, and I actually say it in the article, but I think if you agree with that passage from a QMR's book, then your second point is wrong, and also, by the way, a QMR's overall position on NFIB versus Sebelius turns out to be wrong.
Well, thank you for your unbiased opinion. So I think at this point, it would be appropriate to open up the floor for anybody that has questions, and if you would, use the microphones. And Jeff, get a mic.
I got a mic.
Would you address it to any particular member of the panel?
Yeah, I think it'll go to Professor Ryan and Professor Moncrieff. And first, we ought to point out that Sebelius was the first time in about 80 years that the court had struck down a conditional spending provision. But then I look at the Roberts test and I say, so what, right? Congress has the power to repeal the entire Medicaid Act. And so Congress could say, or could have said, Public Law A, B, C, and D are repealed, and the Affordable Care Act is now this, plus what happened to be formerly the provisions of Public Law A, B, and C. This would certainly be a workaround, the idea of an amendment that carries the bigger stick but too small of a carrot for the states. So the first question is, do you see anything in congressional power that would prevent this, setting aside mechanics and inertia for a second? The second question is, if Congress were to do this, were to repeal these various laws and then simply reenact them with the additional provision of, for example, the Medicare provision that was in the Affordable Care Act, do you think that the court might just simply call the bluff and somehow invade that exercise of legislative power?
So I mean, it's an interesting question. Obviously, if they had done repeal and replace, and this is something that a bunch of amicus briefs that I was involved in talked about, you could have taken away Medicaid and replaced it with Medicaid 2. The state's participation in Medicaid 2 would have been voluntary, but it would have been the same thing as taking away Medicaid 1 funding for any state that didn't join Medicaid 2. So then there's been some thought that the Supreme Court might create some doctrine of sort of a basic reliance type thing that the states would have to, that Congress couldn't just repeal a spending program of that kind. I don't know whether that's true, like whether that would happen or not. I don't know if the Supreme Court would go there eventually or not. But I think we can't have a conversation about this with the mechanics to the side, because I think it is just absolutely politically impossible for Congress to do that. So excuse me for fighting the hypo, but I think the mechanics matter tremendously. And when we're talking about federalism, the political safeguards of federalism have to be part of the conversation, even if they're not the entire conversation. And I think the states have too much power in Washington for that to be a viable thing for Congress to do. The one piece of evidence that I'll cite to support that is that the Medicaid expansion is a 100-0 federal match for the first several years, and then a 90-10 federal match after that, despite the fact that normal Medicaid ranges federal match of 50 to 83%. So the states are able to extract a lot out of Congress when it tries to shift these programs. And so that was a two-part answer. I think maybe the Supreme Court would get serious about preventing that kind of end run if Congress were able to muster the political votes to do it. But I think that the if is a huge if. I just don't think it would ever happen.
Very quickly, to preserve time for another question, I'll just say that I think the answer is yes to the second part of the question. There would be a call of the bluff, and if the court was so comfortable effectively rewriting the statute to require the second track of Medicaid to be open, I see no reason why the court wouldn't feel equally comfortable calling a bluff like that and saying that that was impermissible under the principles of the rule it had set forth.
Do we have another question from the floor?
Sure. So I always have this question about why people think that if Congress gives a lot of power, I mean, the court gives a lot of power to the states to turn down federal money or turn down part of federal money, that they will, in a sense, push the states out of the job. Because why wouldn't you assume that the governor, if he really wanted the job, would simply agree to conditions that would contract around whatever document the court creates? It's rather like my dean coming to me and saying, we're going to double your course load. And, you know, I say, well, I'm going to walk if you double my course load. And your theory is, I'm going to price myself out of the job. Why don't you think the governors are rational enough to say, oh, well, we, in theory, have this power, but we really like administering Medicaid. And so we'll simply strike a deal with the feds that essentially contracts away all the constitutional entitlements the court gave us, which the states clearly have the power to do. So I'm confused. Has there ever been a case where a governor has, because of something the court has said, lost power that the governor wanted? I can't imagine that the case. I can imagine governors turning down Medicaid, because Medicaid is a silly program to administer at the state level. It's ridiculous, and the only reason they do it is the feds are desperate not to cover it, because it involves poor people, and Congress does not like to help poor people. Right? So typically poverty programs get shoved off to the states because there's no political margin. But your theory seems to be, and it was Breyer's and Prince and Ginsburg's and Sebelius, that somehow the court's going to give the states so much power that the states price themselves out of the job. And I just don't see that happening. Could you spell that out for me?
Are you talking to me?
Both of you guys. Anybody else? And give me an example. I want to spell it out case by case. The governor comes up and he gets fired. Sorry, we're just going to do it ourselves. And the governor can't lower his bid.
I'm not smart enough to act as quickly on your hypothetical as you want, but what keeps coming to mind while you're talking to me is that it seems to me that this happens in environmental law in various degrees all the time, but to the benefit, I think to the benefit of everyone, and certainly to the benefit of the states, and that environmental law, I'm not sure I agree with your point that Congress hates poor people and that's why they shift Medicaid off to the states, but I do think that in environmental, But anyway, we'll talk more later. I do think that in environmental and all other social service contexts, sometimes it makes sense for state and local implementation because of the special capacity that kind of inheres in local and state governance that doesn't inhere in the federal level in terms of boots on the ground and local knowledge and expertise, all the usual things. So in environmental law, for example, there are tons of examples of conditional preemption, the federal fallback kind of thing I was talking about. And there's always this implicit threat that if the states don't participate, the federal government will take it back from them. But everybody knows, there's plenty of, and I've done plenty of field research to kind of show this, that the federal government needs the states more than the states need the federal government to make those programs work. And that is leverage for the states at the table in terms of discussing how exactly they're going to collaborate. The federal government couldn't possibly administer many of those environmental programs without the help of the state, and it means that the states often do sort of threaten to walk, and then the federal government has to kind of capitulate and redesign a program to keep the states at the table. So I'm not sure if that's exactly, it seems to be very related to what you are. That's why I'm confused about your question, because I think that we maybe do agree on this point.
So wait, so no, so I think where you run into trouble, I totally agree with everything that you're saying, except for the existence of Douglas, which is this case that nobody's paying attention to, but says that, look, there's a, so here's the scenario, right? The state Medicaid agency walks into CMS and says, here's our plan for Medicaid. And CMS says, well, you're not really in compliance with some of the federal Medicaid Act requirements. And so you have to get into compliance with the Medicaid Act requirements or we're going to stop giving you money. And the state says, well, we can't, we don't want to, we refuse to, for whatever, like we're too cash strapped. That's usually why they cut reimbursement rates. We can't afford it, it's too hard. And so I dare you to withdraw funding from me.
Why
right?
would they do that?
Why would they say we dare you to?
If the feds would walk, why wouldn't they say, you know what? We'll raise our taxes.
Well, so the point is that NFIB creates some power on the state's side to say, well, we're just going to stick with what we're doing. You can't do anything about it because it's unconstitutional for you to do anything about it.
They don't have to exercise that power.
And they never have before, right? They've never actually tried to enforce the Medicaid Act against the states. Everything has happened through bargaining, and states have Medicaid plans in existence. Almost every state has a Medicaid plan in existence that violates the federal Medicaid Act, right? So my point is that under Douglas, now individuals will sue CMS for approving state plans that violate the Medicaid Act, right? And so CMS is going to have judgments against it, saying it was arbitrary and capricious for you to have approved this state's Medicaid plan. And then what happens?
The state comes back and says, we'll pay those judgments because we love this program so much.
I think
what this demonstrates.
Hates the program.
I think what this
The
demonstrates.
state hates the program.
No, I'm really going to make this point. I think that what this demonstrates is that there's a lot of overlap between the interests in the state and the federal actors in these pictures. And that the reason that they're not walking, I'm an academic, the reason they're not walking.
I think this argument is going to take up after we're finished here.
This is why I recommended having federal judges moderate law professors.
Yeah. Well, why don't you all join me in giving a hand to the members of this panel?